give a press statement today, including a press conference as you're having now, so that you can ask questions. As you are aware, we have put in an application yesterday by way of a notice of motion to the Court of Appeal, supported by an affidavit of Datuk Sri Najib personally. Yeah? This is an application, to put it in a nutshell, to adduce further evidence and materials that we have discovered only recently. Because for the last 3 years, various authorities, investigation authorities, and also prosecution authorities have been claiming that they do not have such evidence, and such evidence has been kept away from us. Now, this evidence that I'm referring to, some of you may have got a copy of the affidavit as well as a notice of motion. If you don't, what we can do is, because this notice of motion and the affidavit has been served to the prosecution, we can disclose it to you, because I noticed that in some of the materials that have appeared in the media, some guesswork has been made as to the intention behind this application. And I think it is ideal that I tell you why we made this application. This application is made starting from the 19th of November. We began to receive disturbing news that we have always suspected, which we had endeavored to get more information, but we have always been blocked, and this information has been carefully concealed from us. On the 19th, the MACC issued a press release on the recovery of fund assets of One Malaysia, or rather One MDB, from Singapore. In that press release, they have stated that they have recovered, and the government of Singapore has repatriated a sum of 15.4 million US, which is equivalent to about 64 million Malaysian ringgit. Now, this has been repatriated from a company they have recovered this from, namely Cutting Edge Industries Limited, belonging to, among others, Taufik Aiman, the husband of Tan Sri Zeti Akhtar Aziz, the former governor of Bank Negara Malaysia. Now, you probably would have read some parts of this affidavit. You know that there are some companies, apart from Cutting Edge, there's another company where Tan Sri Zeti's husband has got shares together with his 2 children, the 2 sons. And we have also recovered, or rather got and obtained, statutory declaration from all these individuals connected with the husband as well as the husband, confirming that this certain amount of money is in that particular account, and that they have agreed to waive claiming those amount of money. This clearly would mean that those amount of money is not being claimed by them simply because the money were not lawfully obtained. Now, the fact that MACC recovered this money from Singapore clearly show that this money has got ties to One MDB. Now, that is as far as the 19th of November, where MACC make that announcement. In October and December 2020, about a year before this, you will remember that articles were published by online news portal that Zeti and her family had received millions of dollars from Jolo. This came out, and we made attempt to get discovery of more facts. but we were blocked. Yeah, nobody bothered to give us, the prosecution didn't give us any information. And likewise, the investigating agency did not give us any information. And then, as I've said, I personally have seen 4 statutory declarations, and these were signed by Taufik Aiman, the husband, and his 2 sons, Alif Aiman Aziz bin Taufik and Abdul Aziz bin Taufik, their 2 children. They have signed 4 statutory declarations, the 4th one being the company declaration. Now what they have said in that declaration is that they admitted being the beneficial owners of the specified bank account in CIEL held in UBS AG Singapore. And then they said they relinquish all claims to monies held in the said bank account, and this must relate to the 64 million odd, the equivalent of the Malaysian amount, which the Singapore authorities have repatriated to us, or rather to the MACC. And then they consented to the said monies to be transferred to account that may be determined by 1MDB. So they've connected it to 1MDB, and that is therefore 1MDB's money. And they consented to the Singaporean Commercial Affairs Department making an application for an order for the said monies to be transferred to the accounts that may be determined by 1MDB. So clearly, there is more than enough proof, as you can appreciate, that this money is tied up to 1MDB, and now we know this money has gone to this account or rather through Jolo himself. So through this payment, which is from 2008 and 2009, there's a company called Iron Rhapsody. They received a total of USD 16.219.409, which is about 16 million odd US. And this money was received from Acme Time Limited, a company, and then Gutamba Investment Limited, Asset Central Holdings Limited, and a law firm regularly used by Jolo called Sherman and Sterling. All these companies that I mentioned has connection with Jolo, and he operated through this legal firm overseas called Sherman and Sterling. The bulk of this fund was said to have originated, if you were following the SRC case as well as the 1MDB, this money came from the money Jolo illegally made through secret profit of the 5 billion Islamic medium-term note, the IMTN. So this money was made from there, and that's how the family of Tan Sri Zeti received it in Singapore. Now, that's as far as Tan Sri Zeti and his family and her family are concerned. Now, on the 20th of January 2021, my solicitors wrote, or rather we wrote, when I say my solicitors, this Dato' Sri Najib is saying this in the affidavit. We wrote on his behalf to the MAS, which is Monetary Authority of Singapore, and the Commercial Affairs Department of Singapore to obtain verification and documentation relating to the accounts of CIL, Iron Rhapsody, Jolo, and Nick Faisal Arif Kamel, and the legal proceeding taken towards seizure of properties. When we wrote, we received not much cooperation even from Singapore. So we were blocked by the Malaysian investigation authorities as well as the prosecution. We were also blocked by the Singapore authorities. But until recently, when an announcement was made that money was received from Singapore by MACC. Now, after the MACC has declared that, you remember on the 22nd of November, which is 2 days later, 19 was the MACC announcement, and 22nd November 2021, the Law Minister Wan Junaidi Tuanku Jaafar was asked about the issue of the 1MDB related monies being transmitted to the account of Zeti families in Singapore. And he confirmed, this is what he said. He said that the Malaysian, or rather the Royal Malaysian Police Department had known about this since 2019. The Minister of Law confirmed this. But when we asked in 2020, they said they will not give this information. And in fact, they almost pretended that they have no such information. Now, this is reported, as you can imagine, on the online media in an article published on the 22nd on the Free Malaysia Today news portal. Okay? And then, what is quite surprising, so you have one MACC, investigation agency, then he moved to the Minister of Law, who confirmed this. Now he moved to Tommy Thomas, the former Attorney General, on the 24th of November 2021. It can't be 24th of December, there will be almost Christmas Eve. 24th of November, Tommy Thomas, the former Attorney General, was asked on his thoughts on ZETI and 1MDB, and he candidly admitted to having the knowledge of the role of ZETI and her husband in facilitating Jolo. That's very important. Tommy Thomas himself said he has knowledge of this during his time as Attorney General, of ZETI and her husband and the family, connection with Jolo, and how they facilitated Jolo in Jolo's activities. And Tommy Thomas further revealed that there were investigation papers opened by the MACC against ZETI, but claimed that he had not had sight of the same during his tenure as the Attorney General. So the matter was left there because he never got back the investigation papers, and then he retired, or rather resigned. Yeah? Therefore, what we are saying is, this evidence that we have now got is credible because 3-4 credible people have confirmed it in Parliament, outside Parliament, and the MACC has confirmed it. So now, this is important for our client, and we want this extra evidence, the new evidence, to be adduced at the appeal in the SRC, because the SRC decision has not been given. So it is still within time for the Court of Appeal to consider reopening so that we can put in this evidence, because this evidence, I will tell you in a short while, why it is so critical. But apart from that, you remember that in the course of the SRC trial, Datuk Sri Najib, through us and also through himself when he gave evidence, he has said that in 2011, Mr. Chia Teck Kwang, who was the MD of MBank, Datuk Sri Najib has passed the information to him that he will be receiving substantial amount of donation from the Saudi, and he had told Mr. Chia Teck Kwang to ensure that all rules and regulations were met, and Chia Teck Kwang fill up form and inform Tan Sri Zeti and Bank Negara of this development, and so that they can receive the consent to receive the money. And Mr. Chia confirmed that he had duly informed Zeti of the opening of the account in MBank in 2011 and the purpose for the opening of the account. And then Datuk Sri Najib himself testified that he has informed Zeti personally, not just Chia, through Chia, but also Zeti personally. Datuk Sri Najib has informed at least once, and this was in evidence in court. And then you have Chia as well as Joanna Yu. They confirmed that between 2011 and 2014, when there were substantial funds that came in from overseas into his various accounts in MBank, there were 4 letters which were issued by the royalty of Saudi Arabia, which also accompanied the request for permission and information to Tan Sri Zeti and Bank Negara. They accompanied these 4 letters. Chia Teck Kwang notified Tan Sri Zeti and also gave the 4 copies of the letters. Now, there were also evidence that we know for a fact, because Joanna Yu as well as Chia Teck Kwang, and in particular Chia Teck Kwang went with the number one in M-Bank, a person who has now left M-Bank, somebody by the name of Ashok Ramamurthy. And they had a meeting with Tan Sri Zeti in relation to all the transactions pertaining to Datuk Sri Najib's accounts. So the matter that I want to emphasize is that not only Datuk Sri Najib did not keep it secret, he openly made the application and he openly declared that he will be receiving this money from Saudi, and these monies are supposed to be donation. That is as far as Datuk Sri Najib is concerned, and that's what he believed. Now, and then Datuk Sri Najib also said that he informed Zeti that if there are any issues pertaining to his application, to raise it with him. Nobody from Bank Negara, especially Tan Sri Zeti, has ever raised any issue or raised any red flag pertaining to the money that came in. Okay? And of course, Datuk Sri Najib's defense is that he never knew 42 million in fact came from SRC. He never knew because nobody informed him that. Yeah? And he's always believed that the money came from the part of the donation money. Now, that is important because it shows you that you remember Datuk Sri Najib has testified in court. He says his own officers have failed him in the Prime Minister's office. You remember one or two officers who were supposed to ensure his compliance with the bank have failed to do that. Now, secondly, he says his own bank, namely M-Bank, whom he relied upon to provide him safety and information, have also failed because the bank, instead of working with him and he's appointed, he's appointed the mandate holder, namely Nik Faizal, did not comply with it. Instead, the bank, people like Joanna Yu, was contacting people like Jolo and getting instruction from Jolo when Jolo was not in fact the mandate holder. Alright? Now, so he says the last bastion, namely the safeguard, was Bank Negara. And he says now he has evidence that even Bank Negara, nothing less than the governor, was compromised by Jolo. So he says every safety measures that was put in place to alert him if there was anything wrong has failed. So this is the beginning of what I say is relevant to his defense, because if he had known about this, Zeti would have been a very critical witness for the prosecution to call, and so that we can cross-examine. At least the court or us should call Tan Sri Zeti, and we could cross-examine her on her role and why was she involved with Jolo, and why she did not declare her involvement with Jolo or her family involvement with Jolo. Now, you remember, this is an interesting facet that I think even from Malaysia we find this very, very unusual. You know, many things can happen here, but even for Malaysia this is unusual because Tan Sri Zeti, in May of 2018, the former Prime Minister Tun Mahathir Mohamad formed the Council of Eminent Persons, which was led by Tun Daim Zainuddin. And who were these people in the Council of Eminent Persons? First of all, it was Tan Sri Zeti. Then it was Tan Sri Hassan Marikan, Tan Sri Robert Kwok, and Professor Jomo Kwame Sundro. So you find the person who is closest to Jolo knew Jolo a lot earlier than even Datuk Sri Najib, which is Tan Sri Zeti, and her family, closest to Jolo, were asked to be in the Council of Eminent Persons in order to monitor about this matter pertaining to 1MD. And then there is a MDB task force headed by Tan Sri Abdullah Osman, who was a former Attorney General. I'm sure he didn't know either. As chairman, he didn't know that in his task force, namely Zeti and others, Zeti was certainly there, or rather Bank Negara, headed by him, and then the Attorney General's chambers, MACC and Bank Negara Malaysia itself. And Zeti represented Bank Negara Malaysia. And I am sure Zeti did not disclose this fact of her connection with Jolo to either Tun Mahathir or to Tun Daim Zainuddin or to Tan Sri Abdullah Osman. I'm sure this was not done. Because if this was done, I'll be very surprised that she was still appointed to the Council of Eminent Person. So you can see there is a lot of game being played, suppression of evidence, and in fact concealment and misrepresentation. Yeah. So what happens in this task force? In this task force, she was, among others, commissioned to do investigation of 1MDB. So basically she was investigating, among other things, she was investigating herself, which is a total conflict of interest because she never disclosed her role in this particular issue. So how does my client, or rather how did my client get affected? Now the evidence that she so-called gathered, because she played a prominent role in Bank Negara, this evidence was curated, adjusted in a layman language, so that it conceals her part, but projected my clients to be the main part. So my client became the victim. Nobody listened to his defenses, and this is why we want his this further evidence to be adduced in the appeal that is yet to be given the decision on the 8th. Alright? Now, as a result of this, my client have lodged a police report, I think you know, in Dang Wangi on the 27th of November 2021, just a few days ago. This is Dang Wangi 27173/21. You also have a copy, I think, because if you get this, you will have it. Yeah, and it will be in your digital, ataupun in your email. Now, that is the reason why he lodged the report. Now, then we come to, there is another interesting facet. You remember Nick Faisal? Nick Faisal was supposed to be his, what do you call it? The mandate holder for the accounts that he has, because Nick Faisal was somebody, he testified, come from a good family, because Nick Faisal's father was the first Malay Speaker of Parliament. So he says, when he was introduced to Nick Faisal, he was quite delighted because Nick Faisal come from a good family. He retained Nick Faisal and made him the mandate holder. But now we have received, because this evidence was hidden from us, Nick Faisal himself received substantial funds relating to 1MDB. Okay, now the press release of MACC on the 19th of November also outlined that as part of the recovery of 1MDB funds, on 12th of November 2021, the Commercial Affairs Department of Singapore had repatriated USD 813.27, namely about 865,000 USD, belonging to Nick Faisal, the former CEO of SRC. So you see, SRC, the management, remember that the defense was that the management failed totally to inform Dato' Sri Najib. Now, the CEO of SRC, we have got now proof, because it is now admitted by MACC, that he received about 865,000 USD. This is so far that we know. How much more he received, we are still not aware. Alright, now, therefore, Nick Faisal had personally benefited from the funds of 1MDB. During the trial, we were not aware of this. This is also materially relevant to the issue which were before the trial court, and the issues which are before this honorable court in the appeals. Now you remember one of the things the High Court judge made observation when he gave the judgment was that Nick Faisal did not benefit anything. That was in the judgment. But that's because we didn't know that Nick Faisal actually benefited 865,000 USD. So far that we know, he could, in all likelihood, he would have benefited a lot more, being the CEO of SRC. And my client didn't know about this. Otherwise, we would have adduced this evidence to show this is how systematically my client was misled by SRC, the management team, who were working hand in hand with Jolo and individuals in the M-Bank. Individual officers in one M-Bank, dishonestly and misled our client into thinking of a certain line of thinking pertaining to the money that he received from what he perceived to be from Saudi. Alright? Now, his defense, my client defense, has raised the issue that Nick Faisal was a subordinate of Jolo. The learned High Court judge did not believe that because he says Nick Faisal did not receive a cent, did not benefit anything. Now that if he knows the truth, because MACC now confirmed, his finding will be quite different. That's why we think that this evidence in relation to Tan Sri Zeti, the entire family benefited millions of US dollars from Jolo directly. Now we have Nick Faisal benefiting from Jolo to this amount, but maybe more. And even Tan Sri Zeti, I'm sure there could have been a lot more. They benefited from various other occasions. But this is the amount that MACC, with the help of Singapore, discovered. Sorry? Yeah. There are also other materials we're looking into, but typical of my situation, I normally do not say out names unless I've got proof. But you will find other names are in the police report. There's a former minister responsible to the creation of SRC who also received millions of dollars, which we never knew before. So there's a total failure of the system. My client became the victim. Alright, that is the relevance of why we have made this application now before the Court of Appeal. And I am making this press statement simply because this morning I was troubled, and yesterday too I was troubled when I read some media in the digital format have made accusation that this application that we made, we may have some other motive. And why is a last minute application? You know, the last minute application is not caused by us. Because on the 19th of November, for the first time, MACC disclosed this. And then on the 20th November, the minister disclosed it in Parliament. And then on the 24th of November, Tommy Thomas confirmed that he knew it a lot earlier. And mind you, Tommy Thomas was the prosecutor in SRC. He never told us. He never told us that Zeti was involved in this. Yeah, and that Zeti facilitated Jolo in many ways. The whole family was involved. So I will stop there. Our application is to adduce the entire affidavit where we make this, my client has made this averment. We also would want to have oral evidence to be given by two witnesses, namely one is the IO, the other is we would like to invite Datuk Sri Azam of MACC. Mind you, we are quite happy that Datuk Sri Azam has authorized MACC to disclose the fact that this money were repatriated to Malaysia from Singapore, the recovery from Tan Sri Zeti's family account. We are quite happy that MACC was quite upright. We only wish that had been told to us a lot earlier, but nothing is late, and that is the reason why we make this application. Yeah. So in short, we are saying there was suppression of evidence, and now we are trying to make it correct. All right, I want to stop there. If there is any question that you may want to pose, you can ask me quickly now.
Now, what happens? The decision is expected to be made on Wednesday.
On the 8th, yes?
Yeah. So you have filed this application. So
yes.
What is the next thing that will happen?
Okay. As long as a decision is not given, the matter is still pending. I mean, that is quite clear. Yeah. But the decision itself, as you know, has been pending for the last 6 months. So the fact that we discovered this by sheer accident and coincidence, it's not our fault. We discovered it beginning from 19, culminating on the 24th, and we filed this yesterday. We didn't delay at all. Within days of discovering this, we make some affirmation. My client lodged a police report, and we make this application. So what I would expect the Court of Appeal to do is to make a decision to hear our application, whether to allow it or not to allow it. But we thought we should make this application, disclose as early as possible, because otherwise we may be accused of ourselves not using this evidence that has been concealed from us for so many years. We don't want to be accused of the same. Right? So they should hear us and then make a decision. Whether what is going to be admitted or not is going to affect their final decision, that is something in the jurisdiction of the judges. It's up to the judges. It is their discretion. It is in their good judgment. Yes.
Sorry, just pulling what Sarah did ask, in the event the Court of Appeal decides to appeal, can you tell us what the procedure, what will happen then?
Okay. In a situation of new and fresh evidence, this is under the topic of new and fresh evidence, to be adduced so that it forms part of the record of appeal, because this evidence was never there during the trial. Yeah? So first of all, I would have to ask for leave. Leave meaning, in a normal layman term, permission from the Court of Appeal to adduce this new fresh evidence. Once they give me leave, I then adduce, first of all, the affidavit. Secondly, there is that issue that I want to question. One is the further questioning of the IO. You remember the IO gave evidence. He should have known this because he's from MACC. I want to know why he didn't tell us this. Then of course, Datuk Sri Azam, obviously MACC, when they make that statement about money recovered from Singapore, namely from Zeti's family as well as from Nick Faisal, obviously Datuk Sri Azam being the number one MACC, he would know this. So I want to ask questions. I'm sure he would be, if I ask him question openly in court, I'm sure he will give us details as to where this money come from, when they got to know this, and so on and so on. That will be relevant in relation to Zeti as well as Nick Faisal. These are oral evidence that the Court of Appeal may have to set a date for these two witnesses to testify viva voce, that means orally. So two things can happen. One is they allow the leave, or they don't allow the leave. If they do allow the leave, they may say, we only allow the leave of your affidavit, Datuk Sri Najib affidavit. We don't allow viva voce evidence of the two witnesses. Okay? And because this cannot be done in the High Court, it's got to be done in the Court of Appeal. Okay? Because the High Court has finished, functus officio. So they may say, we take the affidavit, but we don't want to hear viva voce evidence. Or they may say, we take the affidavit and we also want to hear the viva voce evidence. And thereafter we decide whether it's relevant for our decision or not.
So in the event the court says, put on, meaning they refuse to hear, can you appeal on the Court of Appeal?
Well, if they refuse to hear, that means they will deliver judgment.
Yes.
Or whatever they have already more or less decided. in favor of us or against us, that is beside the point. But the fact that we make the application and assuming it is refused, it will become part and parcel, assuming we lost, okay? It will become part and parcel of our appeal because we made the application. It will be a ground of the appeal. Of course, if we win, it becomes
Then we have the court, federal court.
federal court. Yeah. I'm sure either way it will go to federal court. We win or we lose, the matter will go to federal court by either one of us appealing. Yeah. There is from the age in the Zoom, yeah. The IMTN bond flip happened in 2009, which was before the SRC's time. So how is this relevant to the appeal? So it is relevant to the appeal, if I may answer the question, because the money from the IMTN, Jolo make substantial amount of profit to the detriment of 1MDB. At that time it was called TIA. Alright, remember? The first bond was IMTN. Now from this money that Jolo made, he benefited the family of Tan Sri Zeti. The fact that Tan Sri Zeti's family was benefited is relevant for two things. Namely, he knew Tan Sri Zeti and family a lot longer than Datuk Sri Najib. That's very important. Okay. Number two, the fact that Tan Sri Zeti and family has been compromised, even though she was sitting as the number one in Bank Negara, is extremely relevant because my client sought her help to alert my client if there is anything wrong. And whether my application, I'm speaking on behalf of Datuk Sri Najib, whether Datuk Sri Najib application to bring in money, which is money according to him was donation money from Saudi, whether Tan Sri Zeti would have taken the trouble to really look at it, or she was looking at it from a jaundiced eye. Namely because she benefited money from Jolo. So why should she alert about Jolo? So my client is the one who suffered. So that's why it is relevant. I hope I've answered that from the age. Now there are two more questions because we are also going Zoom. The defense was offered Tan Sri Zeti as witness during the SRC trial, but she was not called. So why examine her now? Okay, the answer is very simple. When Zeti was offered to us, you know, we don't have Zeti's statement. We do not know what Zeti said. So the rule of the defense, the rule of the game of a good defense counsel is, you don't call a witness who you do not know what he or she is going to say. But if we had known that she and her family received substantial amount of money from Jolo, I would have made an application under section 425 of the Criminal Procedure Code to ask the court to call her so that as a court witness I can cross-examine. Okay, now under section 51A of the CPC, as you know, which is a new thing, the so-called, they give us discovery of everything. So now you can see, we were not given everything. We were not given every document that we were entitled to as a matter of discovery under section 51A. So what kind of trial my client had? So my client went to court in a boxing match, in a manner of speaking, with one hand tied behind his back, because he was not given everything. So this is his complaint, that he has not been given the right to a fair trial, which the Constitution of Malaysia guaranteed under Article 5. Next one. Yes, the next question from Reuters, I've already answered. I think that question came perhaps simultaneously. Namely, how would my client, Datuk Sri Najib, benefit from this application? And the disclosure of this evidence that we have just provided. Okay, any other question? Sorry.
So the Court of Appeal will be hearing this application on next Wednesday.
No, they haven't fixed a date. They haven't fixed a date. I hope they fix a date earlier to the 8th. Yeah, which means Monday, whatever. Hear us and then make a decision whether they will still nevertheless deliver decision on the 8th or maybe slightly delayed. We don't know, because you see, we have already been waiting for 6 months for the judgment. What is there for another 2 weeks or 3 weeks to wait so that real justice is done?
So from the onset of this trial, sir, you said you believe in the justice system of the country.
Yes.
If you are given the silver bullet, sir, and you are facing the judges today, right now, what will be your 3 line or 4 lines message to them, that they have to hold justice on this country?
Yes. One of my biggest point that I want to raise is, my client never received a fair trial. The disclosure system was not made fully. I would have to say that. Yeah, because one can never know, because apart from the fact that Justice Nazlan did say, with the greatest of respect, he did say that Nick Faisal never received any money. So why should he did a forgery, or rather, you remember the 11 what do you call that document, rentas form, which were faxed to the bank, and we have proven that these rentas form were not the signature of the 2 individuals, namely Nick Faisal and Datuk Subo. All right, they were just simply copied and pasted. And then as compared to the original, whenever there was original which is supposed to be sent, the signature were totally different from the copy and paste. So it is very, very troubling. But the court found, that Justice Nazlan found, why would Nick Faisal be doing that? He didn't benefit. But that's because the judge did not know, as we did. To be fair to the judge also didn't know that Nick Faisal received a lot of money from Jolo. And there are many other banking matters which escaped our detection because Bank Negara was compromised.
So this latest development concerning ZT, isn't it more relevant to the 1MDB cases than the SRC case?
It's relevant to both. You're right. In 1MDB, the prosecution promised they will call ZT. And we cannot wait to get her to be cross-examined. Yeah, we are anxiously waiting. But in SRC, they just offered to us like as though she is not significant. When they knew, the prosecution should know that ZT was being investigated. They never told us in SRC. If they had told us, we could have made an issue out of this.
The reason I ask is that the SRC case involves more of the misappropriation of KWAP money, not
Right.
the 1MDB money.
Correct.
So how is this development relevant or pertinent to SRC?
Okay. The money came into SRC just as the money went into 1MDB. 2 separate sets of, or rather many sets of money. But the one that came into SRC was the co-op money, the 4 billion. Okay? Okay. Now, whatever monies that came into SRC, the fact that is relevant is this. My client alerted Bank Negara, alerted his own bank, M-Bank, and say, hey, money is coming. These are the 4 letters that was provided to the bank. The bank took it, nothing less than by the CEO to ZT. And Bank Negara disclosed this. So, why is it relevant is this. Whatever money that came in from SRC to my client, Bank Negara could have a very straightforward opinion. Is this money to be a red flag or not? But because, as I said, when your palm is greased, your eyes get blinded. Or you choose to be willfully blind. That's what happened.
Tan Sri, having said everything that you have said, and based on what you said basically, would you say that today's press conference or press statement or in fact, whatever that you just said, is this considered committing a sub judice contempt or violation?
No.
If not, then why?
No. See, it is not sub judice because we are saying, you see, sub judice is only when we make comments about a pending case. We are not making comment about pending case. What the judges in the Court of Appeal is going to decide, we are not commenting. We're saying this, we are offering you reasons why we made this application, so that you will understand the reason why we make this application. Because as you can appreciate, people like Sarawak Report thinks that because I asked for the aid to be vacated to just a few days later, in order to ensure that my client had sufficient time to return from Singapore, the Sarawak Report said that I was maneuvering a delay of the judgment. So I don't want you guys to think by this application I'm maneuvering a delay of the judgment. I'm not. Because as you can appreciate, who delayed this whole thing is the authorities. On the 19th, they bagi tahu that the Singapore authorities have sent the money quite some time ago. Don't you think I should know? If my own bank negara is compromised, the governor is in a compromise, Lake Faisal is compromised, don't you think as a defense counsel to Datuk Sri Najib, and Datuk Sri Najib personally, he should know? It is his liberty at stake. Now, secondly, of course, I'm clarifying matters which are already in the public domain, because you all know I made the application. And that is why you're asking a very intelligent question, what will happen to this application? Okay? So, and that's not sub judice, because I'm saying to you why I applied. I'm not suggesting to you how the court will decide, because that will be sub judice. I'm not second guessing. I'm telling you the various alternatives that can happen. The court can very well, for your information, not even entertain this and say they are giving judgment anyway. All these are within the discretion of the court.
Just to confirm, this morning President Suryopa was not in court, so will Datuk Sri Najib be there on the 8th?
Oh, he has to be there. You see, he has to be there. When I wrote in for the adjournment, I was worried about this. He'll be back on the 6th, on the 5th. On the 5th, he'll be back. He will surrender his passport on the 6th. But at this moment, I'm not sure whether Singapore to here, they have waived the quarantine to everybody. Yeah, I am told now they have waived. When I made the application, the quarantine was not waived. So kalau dia sampai sini on the 5th, you tambah 7, is 12. It's passed beyond the 8th. That is the reason why I say, can you delay it? And because I offered the reason, because of the quarantine. At that time, quarantine was applicable. So it was a genuine reason, but Sarawak Report twisted it. Okay? And also, my case was on the 8th, my own case. You know, I have been sacrificing hearing of my own case to other cases. But I also need to be clear again. So I wanted my date on the 8th to go on, because the judge also is getting a bit, he's not impatient. I must tell you, I must give credit to the judge. He's not impatient at all. He's been very kind. But I have not been kind to myself. I need to finish my case, which happened to be fixed on the 8th, without the Court of Appeal knowing perhaps. Okay? These were the two reasons I provided.
So, despite the limitations that you expressed, you and your team held quite strongly. You mentioned the case Najib's liberty is at stake. Could you just tell us, as days come closer, and I'm sure you'll meet Dr. Sri, what is the feeling, Dr. Sri, expression that you see in his eyes?
Oh, difficult. How would I read his eyes? I don't think his wife can read his eyes.
Tell us his feelings.
Well, I'm sure I can guess that he's anxious. Anxious, maybe even worried, I'm sure. Okay, just like any other accused person. But I can't go beyond that, because this is expected. Okay? I have got some refreshment and some food. You can just hang on.
Thank you.
The food will come in from the other side. Thank you very much.
Thank you.
Can you get?
Yes,
Sorry? Oh,
yeah.